Morning, everyone. We'll just give people another minute or so to sign on, and then we'll get underway. Okay, tēnā koutou katoa, and welcome everyone to today's contract drafting workshop. My name is Campbell Featherstone, and I'm a senior associate here at Dentons Kensington Swan in the commercial technology team. I can see some people are still joining today's webinar, but we'll get underway. What we can do during the course of this workshop is, if you've got any questions, please feel free to use the question and answer function or the chat function on Zoom. If I can't get to any of your questions today, bearing in mind the limited time we have and the content we're going to cover, we'll look to answer some of those, or at least the best ones, and a bit of follow-up that we'll issue following this, this webinar today. Okay, so I'm calling this a workshop since there's not too much focus on case law today. There's not much guidance in terms of case law when it comes to affecting drafting practices. Or the skill of drafting. I find it's not really a subject that's covered at law school. Certainly not much case law on what constitutes good drafting. Most cases that we have that are contract law cases are about trying to bring meaning to drafting that's not so good. The court's trying to interpret what the parties meant to mean when they put pen to paper. Of course, the best contracts don't end up before the courts. We don't get to see them too often. They're not public. They get put in the bottom drawer and they get relied on only when things turn bad and people know exactly what they mean. What I'm going to do today is share some of my key tips on the drafting process, the skill of drafting, and also take a deeper dive into a few key provisions of interest that you'll come across frequently, and certainly those that offer some of the more frequent headaches when it comes to negotiating externally, but also negotiating internally with the people you're doing the work for, the business that you're doing the work for. And look, some of what I say today, some of you will know this stuff already. They're pretty practical tips. If you've been drafting a lot of contracts over a long period of time, you'll be familiar with some of these topics. But it's still good to reinforce your understanding of how the process works. And for some of you, this will be new. You might just be getting into the skill of contract drafting. You've been maybe thrust a contract that you need to pull together on short notice. So I'm really hopeful that there'll be some real useful takeaways for you on this. Why should you listen to me? That's a very good question. I do a lot of contract drafting. I draft a lot of contracts. I've been working in a commercial law firm for the last 12 years in New Zealand and in the UK. And I've reviewed a lot of contracts as well. I've done a lot of commercial due diligence for some deals where we've been reviewing swathes of commercial agreements for the purposes of reporting on what they say and how they've been put together and the risks that arise. So I've seen plenty of examples of really good contracts, not as many as I'd hoped, and even more examples of some really bad contracts that have been signed up by some pretty big organisations where, for the life of me, I couldn't work out what they actually were supposed to mean. Today's focus is on relational contracts more so than transactional contracts. What I mean by relational contract is a sort of a service agreement, a distribution agreement, anything that has a term that's rather than giving an effect to a transaction. But a lot of the key principles remain the same, and certainly my tips that I'm going to share with you today, they're constant throughout the drafting of any contract. And indeed drafting any legal document where you need to have clarity, where you need to have precision, and where you need to make sure that the people reading it understand what it actually means. Everything that I'm going to talk about in today's workshop needs to be taken into context. So, I mean, to the extent that there are rules, and I'm going to talk about that a bit, those rules are not hard and fast, and they are there to be broken. We don't have statutes telling us how to draft contracts. We don't have case law that says this is what you must have in a contract, or very rarely do you have a case that points to exactly what has to be in a contract. So this is more guidance, this is more tips, tricks, thought prompts that you need to take into account when you're pulling together a document that ultimately someone is going to need to rely on. And of course, needs must. Look, it'd be nice to turn every contract into the Rolls Royce that you're very proud of, and that you can trot out to everyone and show everyone what a good job you've done. But sometimes you just need to get the deal done, and the Toyota Corolla will do. But that doesn't mean that you can depart from some of the key principles or the key, ignore some of the key tips that I'm sharing. I think they can help with in any context, in any contractual drafting exercise, in any contract that needs to be negotiated. And ultimately, we need to never lose sight of the key objective of a contract, which is to reflect the parties' agreement and allocate responsibility and risk with clarity. So there's no such thing as a perfect contract though, so don't put too much pressure on yourself. It's an unfair burden on a contract drafter to try and anticipate every single scenario that could arise. So focus is on trying to cover those key risks, do the best that you can to ensure that you know that the contract, the way that you've drafted it, does what it says on the tin. So here's a few thoughts on why I think drafting is important. And I said I wouldn't dwell on case law, but I have to at least make some reference to it. Case law does suggest that the drafting of a contract is very important. The most recent high-profile case we have on contract drafting is Malthouse and Angatera, which is a Court of Appeal decision. And I'm not going to dwell on the facts of that, but basically what the case is about is one party arguing an interpretation of a contract based on pretty much what the contract said, and another party arguing that it was obvious that something else was intended and that a term should be implied. At the end of the day, the plain meaning of the contract won. There wasn't enough ambiguity to speak of that the court could justify implying additional terms or add any additional colour to the words on the page. What they said was, where there is a natural and ordinary meaning to the term in issue, departing from it for reasons of commercial common sense should only occur in the most obvious and extreme of cases. So all the extrinsic evidence that's available to the court to help them figure out what a contract means is only relevant where it's not obvious on the face of the contract. So this does put the spotlight on us as contract drafters. We need to do a good job. We need to make sure what we're doing when we write a contract reflects what's actually intended. And there's nothing worse than having your drafting critiqued. It keeps our colleagues in the litigation department very busy, keeps the courts busy, but you don't want to be the person whose contract has been hauled over the coals, who's having someone else trying to figure out what you tried to mean. And it's also relevant in the context of a big due diligence. So as I mentioned before, I've reviewed thousands of contracts in the context of purchasers looking to acquire a company that is a party to all these contracts. It's really hard to advise a purchaser on what a contract means when I can't figure it out, when I read the contract and it's not abundantly clear. That also indicates maybe a lack of care or an undue acceptance of risk within an organisation, which can be detrimental to value. So our job is to limit the scope for someone to argue an alternative meaning to the one that we intended. And we're not going to win every battle, and you can always argue, well, that's what we're paid to do, we're lawyers, we're paid to argue alternative meanings. But try and give the counterparty as little to go on as possible. Try and make the contract as clear as possible and take into account the tips I'm sharing today. And more importantly, when you're pulling together a contract, and going back to the basics of contract law, a contract has to reflect the parties' intentions. It's the key job of the drafter to ensure that whoever's going to put their names to the contract knows what they're getting themselves into. And you'll be dealing often with your operational business, your leadership team. They're the ones that have to sign the contract, so they're the ones that need to understand what it means. So the more appropriately you apply these tools to draft clearly and understand how the various provisions interact, the easier it will be to get the buy-in of the people who have to sign the contract that it's the right thing to do. It helps you also get the business involved in the contract and understand, the importance of the various provisions. If they can understand what they mean, they can make a commercial decision about something that often gets pushed to the legal team. So questions of liability, indemnities, etc., often they get abdicated to legal because it's seen as a legal issue. But if the drafting is clear and it can be clearly explained how the provisions work, then you can get the business to buy in and actually make the decision with you rather than leaving you to make the decision. There's a few other reasons why good drafting, I think, is a useful tool. And certainly when it comes to a consistent approach to drafting. It certainly helps to speed up and simplify the drafting process, which means you can get more done in less time. You're spending less time trying to come up with new definitions. You're spending less time trying to figure out what you yourself mean if you have it clear in your head, the approach that you're going to take. It can provide you with some building blocks that you can use in other contracts. So if you have a consistent approach of style, consistent approach of terms that you use, you can reuse those provisions really easily. If your styles vary from contract to contract, it's a lot more difficult to do that. Ultimately, it narrows the obstacles that you need to overcome to reach agreement because you spend less time negotiating what the provision actually means and more time focusing on actually whether or not the provision is agreed at a commercial level. And it sets you up nicely for the future of law, I think, which is automation. So especially when it comes to your templates, use of consistent styles and a consistent approach where you know what the contractual variables are mean that your documents can be easily automated online. And certainly it means that your templates can be set up in a way that makes them much more easily used within your business. So time for my first top tip. And it seems like a pretty obvious one, but you do need to do a bit of preparation before you dive into drafting a contract. It can seem pretty obvious about this idea that you should be prepared, but we do often forget about it when we're really busy and when something's been thrust on us at the last minute. But it's worth taking the time at the outset of a drafting exercise to consider a few issues that make drafting easier. And the first one seems like a really obvious one, and I apologise for that, but it can catch you off guard. You do need to understand who the parties to the contract are, or more importantly, who the parties to the contract should be. So do a little bit of DD, undertake a company search, figure out who's who. Think about who's going to benefit from the contract. So are there affiliates involved? Do they need to be a party to the contract? If not, will they need to be a third-party beneficiary to the contract? Think about who actually owns the rights, for example. Are we talking about a licensor arrangement where the licensor actually owns the relevant rights? Or is this licensor just granting a sub-license? Slightly different considerations there. And consider also whether a party is maybe acting as a principal or an agent or as a reseller to understand the risk that might arise in the context of the drafting. Definitely have spent a bit of time thinking about the key risks, and this is useful to get the business that you're dealing with and drafting a contract for on board early. So ask yourself, what is the BATNA? Some of you might know what a BATNA is, a best alternative to a negotiated agreement. Talked about a little bit in the dispute resolution and negotiation context, but also very relevant for drafting contracts. So ask yourself the question, if we don't do this deal, what does it actually mean for us? Then try and figure out, if you can, what your counterparty's BATNA is. If they don't do this deal, if they don't enter into this contract, what does it mean for them? Have a think about some of the worst case scenarios. What sort of loss could we suffer if this went wrong? Is it just a case of having to find someone else to do the job or provide the relevant product or the relevant services? Or are there some really serious follow-on implications for the business if there's a contractual breach? If you're the provider, what should you be liable for? What's the market practice if things go wrong in the context of the industry that you offer your services? And importantly, how does that align with your insurance? Ask yourself, can you just walk away from this contract if things do go wrong? Or is this something that's really business critical that we need to have some really robust measures in place to ensure that there is no out? And make sure you get a feel for your internal policies as well in terms of things like liability, indemnities, ownership of IP. You certainly want to make sure that you're aligning with those internal policies, at least on your first draft, so that you know that if you're going to have to depart from them, there is an issue and you'll need to escalate that appropriately. And understanding the key risks really helps you understand what your leverage is when it comes to negotiating, and also how much you can push for in terms of trying to allocate risk to the other party. I always find that it's really useful when you're starting with a blank piece of paper, and we'll get onto that in a second, but sketching out your structure, figure out the headings that you want to work through, the likely key terms that are going to be a bit more difficult, but more unusual for this particular arrangement, and some key terms. And then definitely sort out your definitions. And sort out your definitions in a way where you're thinking about the person, how the person reading the contract is going to use them. So think about when you're opening up a contract for the first time, do you want to see all the definitions up front? Treat it like a glossary. That's my preferred approach. All the defined terms are up front. If there are some in-text definitions used, there's a cross-reference to tell you where to find those in the main body of the contract. And make sure that the definitions are actually definitions. So definitions shouldn't contain any operative provisions. It should be more like a dictionary. This is what the term means, not an optional type of arrangement where the definition could mean this in this circumstance or could mean this in another circumstance. Maybe you need to think about splitting up your definitions there. And you need to be really wary of precedents. This is my second top tip. I think they're great and I think they can help you save a lot of time, but you need to take them with a grain of salt. So the use of precedents without appropriate care brings with it a lot of risks. And that is because, to be blunt, a lot of precedents aren't actually very good. So you need to assess them with a critical eye, and you need to challenge them if they're not actually very good precedents and not actually a very good place to start. Don't forget, of course, at the start of the seminar, I said needs must. So you've got to make a judgment call, of course, whether you want to reinvent the wheel. But there'll be plenty of opportunities perhaps for you to do that after the event if you just need to get the deal done. But understand why your precedent is the way it is. A good precedent should be drafted as a precedent, as a template document, on the basis that it will be rolled out on a number of occasions. Often precedents can be the way that you did the deal the last time you did the deal. That's not necessarily a good place to start from. There might have been particular deal considerations that were taken into account, a particularly different counterparty that you were negotiating with. You really need to understand the genesis of these precedents and why they are the way they are. You, of course, need to make them up to date. Have a sanity check in terms of the legislative references in particular. So I'm sure we've all seen references in recent documents to the Contracts Privity Act 1982, which was repealed a few years ago. That's an obvious one. But there'll be some less obvious contractual reforms that might not have been taken into account in your precedent as well. So for example, last year's Privacy Act 2020, yes, we had a Privacy Act beforehand, but it's not necessarily just a case of replacing every reference from 1993 to a reference to 2020. There are some other considerations you need to take into account. A lot of you will be part of international organisations potentially. So some of you will have parent companies elsewhere in the world, and you'll have access to their suite of precedents. Some of those will be a useful source of some pretty technical drafting or some useful provisions. But you need to take a lot of care as to where they were drafted and in what circumstances they were drafted. Certainly US style agreements don't really work in the New Zealand context, or they're certainly not ideal. There's quite a different approach to liability and indemnities. And you'll all have seen the rather aggressive use of all caps, which is something that I'm not particularly fond of. So try and avoid that to the extent that you can. And you need to ask yourself, who are these contracts drafted for? Are they customer friendly? Are they supplier friendly? It's not just a case of switching the parties around. You need to assess the whole contract from the point of view of the contracting party. Lastly, the bane of existence, of our existence as lawyers, is formatting, as far as I'm concerned. Not everyone has the benefit of full-time WP staff. So you need to take sometimes ownership of the formatting of the document, because it helps you demonstrate clarity of thought, helps guide the reader, and it can be used as an aid of interpretation. I've never seen a badly formatted contract that was otherwise well drafted. So what you can do with formatting is really help the reader of the contract follow the key principles, follow the text, follow the way in which the contract's supposed to flow. It really helps to guide the reader. And don't be afraid to draft a longer looking contract that is easier to read. A little bit of white space can be a bit more, can present as a little bit less threatening to someone who has to pick up the contract and read it than a page of densely typed text that is difficult to follow. Okay. I'm going to dive into some of the key provisions that I said we'd talk about today. And the first set of key provisions that I'm going to work through are some of the most important. They're the most likely to need escalation to key decision makers when negotiations get tricky. And they're also the most likely to come out against your own internal organisational policies. So these are, of course, liability. And I've bundled together a few concepts here. We're talking about exclusions of liability, caps on liability. Oh, some raising hands. So is it Mark there? You've raised your hand? Someone, if you've got any questions, maybe pop them through the chat function. Thank you. So getting back to the liability provisions. So you've got your exclusions, your caps, your indemnities, and your exceptions. They all need to be looked at together. They all sort of interact. There's a number of things that need to be considered in the whole. So is there any point arguing about the scope of, say, an exclusion of liability clause or an indemnity if the contractual cap on liability is small? Don't assume that there's always a need to be mutuality as well. You always need to look at liability provisions in the context of the entire arrangement, the arrangement that's in front of you. So tit for tat doesn't always work. Just because a counterparty has asked for the mutuality, say for an indemnity, doesn't mean that you should offer that up. It's not necessarily appropriate given the different risk profile that each party has. What do these provisions all do? Exclusions, caps, indemnities, and exceptions. They all touch on the same theme, which is the reallocation of risk. So it's quite useful to go back to basics and remind ourselves what the default position is if you are silent on liability. And that takes us to Hadley and Baxendale, a case from over 150 years ago, which sets out some pretty key principles about the type of loss that might be claimable by someone in the context of a breach of contract. So we've got a few different types of loss that were categorised in that case. Direct loss, which is loss naturally arising in the usual course of things from a breach of contract. And indirect loss, which is loss within the reasonable contemplation of the parties is likely to arise from breach at the time the contract was entered into. So you need to think about that. If you're silent on exclusions, if you're silent on caps, if there are no exceptions to where the liability provisions apply, then the default position will apply that direct loss and indirect loss will be capable of being claimed by the party not in breach. So you need to think about how and to what extent you need to vary that position. Bear in mind, of course, that Hadley and Baxendale doesn't talk about caps on liability. So the cap arises naturally, effectively. If it's direct loss or indirect loss, then it is capable of being claimed, but that will be naturally capped. The amount, the quantum will be naturally capped. So what do contracts often do? Well, they vary the position that's set out in Hadley and Baxendale. So we can start with looking at exclusions of liability. What is it common to exclude liability for? And often you'll see in contracts that we've specified different types of heads of loss that are excluded. So loss of profit, loss of revenue, loss of anticipated savings, loss of contract, for example, loss of business. It can be a little bit confusing. There's not really a lot of guidance in terms of what those heads of loss actually mean. Well, sometimes, yeah, sure, it'll be quite evident what a loss of profit is. But what is the loss of contract? What is the loss of business? How do you quantify that? So you need to be really careful as to what you're seeking to rely on here. Certainly when you're looking to exclude these types of loss, you need to make sure that in your contract you're excluding that type of loss, whether or not it is direct or indirect. There's case law that suggests that certainly loss of profit, loss of revenue can be direct or indirect. It really does depend on the circumstances. And there's a UK case that points to this, GB Gas and Accenture, where a failure to properly implement some billing software meant that the client of Accenture, GB Gas, underbilled all of its clients. Now that was a direct result of the failure to implement the software properly. There was a loss of revenue. All this underbilling meant that GB Gas wasn't receiving the revenue from its customers that it thought it would. So that was held to be direct loss, a direct loss, even though it was called loss of revenue. You need to be really careful about the terms the heads of loss used as well. I've seen one frequently, which is economic loss. What does economic loss actually mean? In theory, it could mean pretty much anything other than physical damage to property. Is that actually what you want to agree? everything other than physical damage is quite dangerous because ultimately you might not actually have a practical remedy in respect of your breach of contract. But it is very common, of course, to exclude indirect loss. Why is that? Generally speaking, you get what you pay for. Your service providers are there to do a job and they're to do it right. And if they don't do it, they're on the hook for not doing the job right. But they're not on the hook for other costs that arise as a consequence. So Hadley and Baxendale was a classic example. The machine wasn't fixed properly. The loss that was suffered, the direct loss that was suffered, was a broken machine. It wasn't necessarily a natural consequence that the customer whose machine was broken would actually miss out on some business and miss out on a contract. Maybe that could have been made, the parties could have brought that up at the time and could have dealt with how that loss might be addressed. But in the absence of doing so, it's on the customer to manage that risk. That said, sometimes you're paying for a premium service. Sometimes you're paying for something to get done by a particular date or to a particular standard because there is a consequence if it doesn't get done right. And it's certainly, if you're paying a premium for that, you want to make sure that the other party's on the hook. So you really need to be careful and consider what the effects of the exclusion provisions are. One way to do that is to expressly agree that certain types of loss are direct losses. Now, it's a little bit artificial doing this, but it's often used as a way of sort of circumventing or getting directly to the point as to, yep, if there is a breach of contract and a particular type of loss occurs, I expect you to cover that. And that's without being an indemnity. So here's an example here: loss of or corruption of customers' data, certainly relevant in the context of, say, an IT contract where data is being used, data is being is going to be manipulated, or where someone's going to have access to data. You might say, actually, this is something you are being entrusted to take special care of. So if you breach the contract to the effect that I have a loss of data, I do want you to be on the hook for that as a direct loss. It's not necessarily an indemnity, it's not quite the same thing, but it does give the result of liability shedding through to the party in breach. Or think about maybe, rather than dwelling on the different types of loss we've got, the exclusions, is there a better way? Can you have a specific indemnity? Can you think about service credits? They reflect that you're not getting what you bargained for. They have a much more sort of clean and objective measure of saying, this is what you're responsible for in the case of a breach because I have not got the service that I was going to pay for. And don't be too scared about penalty clauses as well. Have a read of Honeybees. We've got a good article on that. Check out our website. Do another session on penalty clauses another day. But certainly the way you want to frame service credits or other provisions which cover compensation in the case of breach, if done properly, you don't have too much to worry about. See some questions coming through here, which I think, given the time, I'll try and address at the end. One in particular, though, Katrina Thomas, thank you. Are we saying economic loss shouldn't be used? Certainly a handy, all-encompassing term. And that very much does depend on who you're acting for. But what you do want to be careful of is, if you're looking to exclude your liability for economic loss, really think about, what is the bargain? What is the bargain that you're reaching with the other party? Are you actually trying to exclude all financial liability? Would you maybe be better off working on actually having a cap on your liability? Just because the court may be trying to find meaning to the term economic loss and what that was intended to mean. I mean, surely the parties intended that there would be some liability if you didn't perform to the contractual standard. So talking about caps can sometimes be the easiest way to manage risk and cut to the chase. So if you have appropriate caps in place, then the scope of indemnities, the scope of exclusions become maybe a little bit less relevant, since you know the worst case scenario. So often, if you're escalating a contract for sign-off to someone quite senior, they'll ask you the question, what's the worst that could happen? And if you say, well, the worst that could happen is that we're on the hook for $50,000, say, that might be an acceptable risk. They don't need to know too much about whether or not they're liable for indirect losses or loss of profit, or if there's a particular indemnity, if they can quantify financially what the cap on their risk is. But let's be honest, it's not usually this easy to strike that balance. You need to find an appropriate balance between the risk and the reward of the contract and the incentive to perform. And often you'll need to balance some competing policies. So you will all have been faced with negotiations where the counterparty has said, well, that we never accept this position, or we never accept an indemnity of this type, or never accept a cap of this level. And in this case, it's useful to have done your preparation. So what is your BATNA? What is the other party's BATNA? How much does this deal mean to you, and how much leverage do you have? I think this answers one of the questions that's been raised, which is around indemnities. You always need to consider the way in which the contract is drafted as to whether or not obligations to indemnify are within the scope of the cap. Now, bear in mind, an indemnity is an obligation to, it's a contractual obligation. So if you have a cap on all liability under the contract of $50,000, for example, then any indemnity under the contract will be the subject of that cap. And we'll touch on in a second exclusions to caps and exclusions of liability, or exceptions, sorry, to exclusions and caps on liability, and whether or not you might want to pick up indemnities in that. Don't forget that mutuality just doesn't always make sense. It really does depend on the relative risk profile of either party. Certainly, if you're a customer, you're looking at it quite differently to a service provider. And that's why in the context of relational agreements in particular, mutuality doesn't actually work. In the more sort of transactional agreements, certainly you can look more to mutuality, but again, you really do need to consider it in the context. When you're drafting, you also need to be really careful about caps that are based on time. So often you'll see a cap that might be limited to, say, 2 times the fees paid or payable in the 12 months prior to the breach or to the loss or damage arising. And that sounds pretty reasonable. But what if you're a month through the contract, you've only paid 1 month worth of fees, and there's a serious breach of the contract and you suffer quite a significant loss? You've only paid fees worth 1 month worth at that time. So the cap on liability might actually be quite minimal. So it's often useful to specify that the cap will not exceed the greater of, say, a specified figure, which is your best estimate of what 2 times fees might be, and say 2 times fees. Have the 2 limbs there that broadly match up, so that if you have that event that occurs early on in the piece, you still have an appropriate cap in place. And sometimes it's going to be appropriate to have separate caps in place depending on the nature of the breach. So consider the obligations of confidentiality. That's a common one to bring outside the cap. But also bear in mind that it's quite difficult to prove loss when it comes to a breach of confidentiality. Consider whether there are specific indemnities that should be brought outside the breach. And we'll touch on property damage in a second. That's for all these questions that keep coming through. I'll do my best to answer as we go along, to the extent not already covered. This is a pretty interesting one, I think, one that is often ignored, or a risk that is often not considered in too much detail. But that relates to insurance cover. So be wary of blanket caps that have the effect of limiting the counterparty's liability in relation to the loss or damage of property. So you need to understand whether or not this could actually jeopardise your insurance cover. So your insurance cover may at the least want to know that you've agreed a contractual limitation of liability with a counterparty that could limit the insurer's right to recover from that counterparty if they were to exercise the right of subrogation. Bearing in mind that they will step into your shoes and they'll have a crack perhaps at the party that caused damage. And if you've contractually limited your liability such that the insurer can't recover, then that might also have implications under your insurance policy. Then again, it might not. So you really do need to look at what the insurance cover is and what it requires. Bearing in mind, you might have got this insurance cover in place on the basis of a whole realm of 500,000 contracts that you already have in place where counterparties' risk is already limited. But you may need to disclose it, or you may need to actually expressly bring damage in relation to loss or damage of real property outside the scope of the cap, so that your insurer could still recover. Definitely something you need to think about, certainly where there is actually a real risk of physical damage to property occurring. But of course, bear in mind a lot of contracts, relational contracts these days, that's not necessarily the case. So it all needs to be considered in context. Now, there's always an exception to every rule. So when you're dealing with indemnities, when you're dealing with caps and exclusions, etc., certainly caps and exclusions, you'll have a boilerplate provision just about which says, the caps and the exclusions do not apply to certain events that might arise, certain types of liability that arise, or reasons why loss might arise. So there'll be specific indemnity obligations that you might want to bring outside the scope of the cap. Certainly when you're, say, a licensee of some IP and you're being indemnified by a licensor against third-party IP claims because the licensor has got full control of that IP, you might not necessarily want to have a cap on that obligation of the licensor. Often see references to liability for personal injury or death. And this often comes in the context of contracts that are governed by or that have emanated from another jurisdiction. They don't have the benefit of ACC. So what does that mean in the New Zealand context? Well, often it's actually relatively harmless to have that in your contract. But you do need to think about actually where are the services taking place? Are they not? If they're not taking place in New Zealand, then it becomes a much more live issue. It's also a really good reminder to consider the parties' respective obligations under health and safety law, which you can't contract out of, and which I'll touch on in a second, you can't obtain indemnity protection for. There's some stuff that's pretty hard to argue against: fraud or fraudulent misrepresentation, any matters for which it would be illegal to exclude or attempt to exclude a party's liability. It's pretty hard to argue against these. There's a few others that you might want to watch out for, depending on where you sit, where your risk is in the contract. Willful misconduct or repudiation is one of them. What if the counterparty just walks away from the contract? And there is a case over in the UK involving IBM and the Cooperative Insurance Society, where IBM effectively just walked away from a contract. It was held to be repudiated through a dispute over a non-payment of an invoice. There was a whole lot of wasted expenditure that was suffered by the client in that case, which, because IBM had walked away, they had to recover or had to try and recover under the contract itself. And there were things like the exclusions of liability for indirect losses, say, or for wasted expenditure, and also caps on liability that actually made it quite difficult. So think about that in particular if you're a customer. What are the implications if the service provider is just going to walk away from the contract? What do you want to happen there? What should you be able to recover in that case? Should you be able to recover everything? Another one that we often see is a concept of gross negligence, which isn't really a thing, to be honest, in the UK or in New Zealand. It's more of an American thing. We talk about negligence here. The courts have pretty much decided that there's not really any distinction between negligence or gross negligence. It's more a matter of degree. If you are going to have to try and define it, see if you can put some parameters around what exactly it means. I've suggested some text there. Certainly, again, needs must. Try and avoid this concept if you have to. But if you can sort of push it so it is really clear that it's a serious, it's a reckless disregard of a known risk that no one would have ever taken, and that gives you a bit more clarity, a bit more to go on in terms of what your contract actually means. Okay. Got a few questions coming through. Good one here from Emma Ritchie. So how does it work to say total aggregate liability under an agreement is limited to 2 times fees in preceding 12 months when fees are variable? Does the total limit go up as term progresses? And certainly, yeah, that's an absolute consideration when you're pulling together any cap on liability. If there is a lot of variability in terms of what the fees might be, you need to think long and hard about whether or not you actually do peg liability to fees paid over a certain time. Can you make the contract a bit cleaner? Can you just specify an amount? If not, why not? Otherwise, you need to think about it with a lot more care to make it precise and as to what happens in the context where fees are variable. You can often link things to maybe the life of the contract, depending on the type of contract that you have and the fees that are payable over that. But we're going to touch on indemnities very quickly. I think you could probably do a masterclass on indemnities one day. Maybe I will. But they're often seen as a bit of a red rag to a bull. Indemnities raise alarm bells amongst lawyers. So they often need to be thought about pretty carefully. And if you are going to put an indemnity in your contract, you are going to request from the other side, you've got to be ready to justify it. You've got to be ready to make it known why the indemnity is needed and what needs to be done to get it through. There'll be competing policies that you need to take into account. The counterparty might say we never accept these indemnities. You might say we always have to have this indemnity in, but ultimately it goes back to your BATNA and whether or not how badly you need the deal. But always ask yourself, do you really need the indemnity protection? Is it something that you actually already have pretty sufficient comfort and cover from in terms of, say, the usual remedies for breach of contract? There are some benefits in terms of having an indemnity obligation in terms of enforcement, say. I provided that the indemnity is actually worded properly, but sometimes those benefits can actually be marginal and you've probably covered off the real risk or covered the risk by having appropriate caps, appropriate exclusions of liability, and of course the remedies that are available in respect of just a simple breach of contract. Ask yourself, of course, is it subject to a cap on liability? So if it is subject to that cap, you always think about it in the context of that cap and how much of a risk profile that presents. Always got to consider it in the context as well of whether or not it's subject to exclusions. So again, it's a contractual obligation to indemnify. If there is an exclusion of liability clause for, say, indirect loss, does the indemnity cover indirect loss or not? There are probably arguments that could be made either way, but make it clear in your contract. Say, yes, it is subject to the exclusion for indirect loss, or no, it's not. It is an indemnity for all sorts of losses that arise, whether or not they are direct or indirect. And that ties in nicely to the next bullet point there, which I'm going to talk about, which is the types of indemnities you might be faced with. I like to classify them in two ways. I was taught to do this by a former supervisor. We look at indemnities as either a sword or a shield. And as the name suggests, the sword can be quite aggressive. It can cut through to claim all costs and losses arising from the indemnified event. So internal losses that you've suffered, loss of profit, loss of revenue, for example, doesn't necessarily arise in the context of, say, a third party actually having a go at the indemnified party. It's whenever we suffer a loss, you'll jump in with that indemnity. So it's quite far-reaching. In theory, it doesn't necessarily matter how remote the losses are, depending on how you've drafted the indemnity. So that means it's not always the most reasonable position to take. What is often more reasonable and more justifiable is if you think of indemnities as a shield, where if there's a third party that claims against the indemnified party because of the indemnified event, then the indemnifying party will step in and protect them from that claim. It's a much more reasonable position. So if someone has a go at the customer, say, or the indemnified party because of something the indemnifying party did, the indemnifying party will step in and will defend you, will hold you harmless. A much more reasonable approach, much easier to get across the line. So think about that really carefully when you're drafting indemnities. And touching on, I think, a question that's been raised around for government in-house lawyers in particular, is it actually legal to give an indemnity? There's certainly situations where you'll need to closely consider whether or not you can actually give an indemnity. And obviously that's relevant to if your counterparty can or cannot give an indemnity. So the Public Finance Act, the Crown Entities Act is going to be relevant there with government ministries, departments, Crown entities. Also be very wary about any indemnity which could be illegal for the purpose of the Health and Safety at Work Act. So indemnities for fines or infringement fees. You're actually liable on conviction to a fine not exceeding $250,000 if you agree to indemnify or be indemnified for fines or infringement fees. Whether or not that would ever be enforced probably depends on whether or not you're trying to enforce the indemnity. But you need to take a bit of care when it comes to that. And certainly bearing that in mind helps focus the mind of the drafter as to risks that might arise in the health and safety context. Okay, so quite a heavy topic to work through, but obviously pretty key. I'm just going to rattle through another tip. Here's a picture of my favourite author, Ernest Hemingway, the master of the short story. And for those of you familiar with his works, he had a pretty terse and direct writing style. So try and channel a bit of Hemingway when it comes to drafting contracts, I think. Keep things short and sweet. Single ideas per paragraph. You don't want a page of provisos, provided that's in capital letters. You need to keep things nice and easy to read, and the shorter things are, the easier they are to follow. Keep a single idea per paragraph and use formatting to your advantage. So break things up in terms of numbering, in terms of ideas, and compartmentalize them. And also avoid what someone else I've heard from refers to as throat clearing language. We see it a lot of the time in contracts. The service provider acknowledges and agrees that it must do something. Now, in my view, it's pretty clear that when you have an agreement, a party is agreeing to do something. You don't need to state every time that they are agreeing to do it. Why not just say the service provider must do X? The same thing happens when you see text that says something like represents, warrants, agrees, covenants, and undertakes to do something. You need to really ask yourself, are you actually achieving what you mean to achieve with all these various terms that to some extent mean the same thing and to some extent actually mean quite a few different things? Representation needs to be looked at quite differently to a warranty, which needs to be looked at quite differently to a contractual undertaking. So this is where precedents are dangerous, especially ones that come from the US. Don't just necessarily ape the wording of the contract that you've seen before, where it says represents, warrants, agrees, covenants, and undertakes. Actually think about what you're trying to achieve and try and make sure that your drafting matches that. I like to set out some standard rules of interpretation as well, maybe at the outset of the contract. So a little bit of a how to interpret this contract guide. So for example, a classic one is whenever you're saying the term includes, it should mean without limitation. It's an example. This is a list, but it's by no means an exhaustive list. If you set that out as a rule of interpretation at the front of the contract, every time you write the term includes, you don't need to worry about writing the term without limitation. But why do you do this? There's a couple of key reasons, I think, keeping things short and sweet. It helps the readability of the contract, and it helps you actually, I think, when you're in negotiations, it makes marking up the document easier. So if you can compartmentalize each concept, then as soon as you realize that you have an agreed one, if you a commercial point or one of the sub-clauses, for example, you can strike that out without affecting the structure of the remainder of the clause. Makes negotiations, I think, way more streamlined. Okay, back to another one of the key provisions that you're often faced with in terms of contractual risk, and that's termination. So again, this is another one where it's critical to understand your BATNA and the worst case scenario. It's all very well spending a lot of time negotiating and refining termination rights, but you need to think to yourself, is it realistic to exercise the right of termination? Does the other party know that you don't have the option to exercise the right of termination? How easy is it actually going to be to get out of the arrangements? This is business critical. If it's mission critical, termination is not necessarily going to be helpful. But often it will be. Often you will need to have a well-drafted termination provision. And what you need to do is take care that, first of all, you want to be able to rely on these termination provisions. What you want to avoid is a situation where you have a termination provision, it's a little bit of a grey area whether or not the threshold for termination has been met, such that you can't rely on it, because that leads to the risk of repudiation. So we've all seen a safety net, and it's great to have the safety net in every contract. Material breach, termination for material breach. It's certainly useful to have in the background and something to rely on. It can often be quite obvious when a breach is material. Sometimes it's a bit of a line call. So what you need to think about is whether or not you can set up objective measures to establish a clear right of termination. So for example, if you have clearly defined and objective service levels, you can contemplate a right to terminate for a persistent failure to meet them. Don't just say persistent, so have a threshold above which termination rights arise. If there are more than, say, 3 failures to hit a service level across a 2-month period, that can be objectively measured. It can be quite obvious whether or not the threshold for termination has arisen. Likewise, you might have a contractual milestone, something that needs to be done by a certain date. If it's not done by that date, then there's a clear breach, but also a clear right to terminate. Failure to pay is another good one. It's quite useful to prescribe with timeframes and processes what it means in terms of a termination right when it comes time to a failure to pay. If you have it in the contract, if it's black and white, the termination right arises because of a failure to pay within X days of being reminded that it's well overdue, then it's quite easy to exercise that termination right without having to rely on whether or not it's a material breach or some other principle of some other implied term that payments, the termination right would apply. And think also of using termination as a bit of a safety valve as well. So termination is not always necessarily going to be linked to a breach of contract claim. Sometimes you might just want an ability to walk away when the service is not meeting your objectives. It's often useful to think of termination in some cases as being a sole remedy for a failure to hit a particular standard or remedy for breach. So it can be a lot cleaner to just terminate the contract, walk away. There's no dispute, there's no claim, but it means that you're free to move on to, say, another provider. You're free to bring the work back in-house. You're free to get out of the contract in particular and get out of long-term obligations that you might otherwise be locked into. And of course, the term itself can help in the context of managing risk in this regard. You know, if you've got a shorter term, so you're not locked in, you can manage the risk of the counterparty not actually meeting the obligations that you thought they would. Ties in nicely to the next slide and the next topic, which is actually dealing with how do you frame contractual obligations. So bearing in mind when you're trying to tie someone to a contract, you actually want to set out with some clarity as to what their obligations are. And again, you need to try and use a bit of objectivity here so that you can clearly establish whether or not the contractual standard has been met. Because then you can establish that a breach has occurred. And all the hard work that you've done on caps and exclusions of liability, etc., really depends on a breach being identified. So if you can't actually identify a breach, then you've wasted a lot of time on those caps and exclusions. And we've probably all seen examples of these various terms being used in a contract. All reasonable endeavours, best endeavours, commercially reasonable endeavours, best reasonable efforts. I haven't seen the term, we'll give it a crack, used in a contract just yet, but sometimes that can be the upshot of what some of these terms actually mean, unless you provide a little bit more flavour, a little bit more colour as to what exactly the parties are being held to. And look, sure, there is case law that where the courts have tried to tell us what all reasonable endeavours might mean as opposed to reasonable endeavours, but it's always very contextual in the context of the particular contract. So if you're relying on the court to tell you what these reasonable endeavours are, you probably lost the battle as a contract drafter. Having said that, needs must, and we can't always, contracts aren't always as clean as we'd hope they'd be. So sometimes you might have to use one of these terms. Maybe try and give it a bit of colour. And interestingly, I came across the term best reasonable efforts the other day, which I thought was a slightly unusual turn of phrase. But this was used in a fairly high-profile contract, which has actually been published. It's the contract between AstraZeneca and the UK government to procure the COVID-19 vaccine. But fortunately, to some extent, the drafters have provided that colour that we need to help us figure out exactly what they mean by best reasonable efforts. Having said that, I've put the definition up there on the slide. Having said that, good luck to you, or good luck to the court in trying to figure out whether or not that standard might have been met or not. But again, it's better than nothing. It's better than just saying best reasonable efforts and leaving it at that. So what can you do when it comes to defining obligations? Again, it's all about coming up with an objective measure. And service levels can be really helpful there. So even if you're not establishing a service credit regime, which to be honest is often more trouble than it's worth, it can help you pinpoint with a bit more objectivity as to the extent to which your counterparty is failing to live up to expectations. And again, it will tie in with your termination rights. If there's a persistent failure to meet those service levels, that's where the termination right arises. You can also maybe have an attempt at defining the particular outcomes or requirements that are to be met. So if the services must deliver a particular measurable outcome, then it's a lot easier to determine whether or not the services have done so, and then whether or not the counterparty is in breach. But always consider in the context of the term and termination rights. And to what extent do you maybe just need a safety valve? If the service levels aren't met because, in your case, maybe as a service provider, you can't just do what you thought you might be able to do because there was a bit too much fluidity at the outset as to the requirements. Maybe give yourself an opportunity to walk away. Another good way, again, if you need to plug a gap, and it's by no means perfect, but if you're going to hold someone to a standard, for example, in terms of carrying out services or performing a particular task, maybe give the person interpreting the contract something to go on in terms of, say, good or best industry practice. You're expecting them to do a really good job. Define what you think that might mean. And it's by no means perfect. You'll see the definition I've got up there. By no means perfect, but it certainly gives you a bit more to go on than just relying on all reasonable endeavours. And a real useful tip for where you're contributing to, say, a project, but perhaps you're the beneficiary of the project on whom other parties are relying for that project to work, but where you don't actually want to take any responsibility if the project goes wrong, because ultimately you're the one who bears the cost. What you don't want to end up with is a situation where you're actually setting up contractual obligations for you to do something. You don't want to be contractually liable for failing to perform these dependencies. So expressly contemplate that any dependencies on which a project relies will not constitute a breach of the agreement by you. Maybe it'll relieve the counterparty, the service provider, from their obligations under the agreement, to the extent that it relies on you having carried out the dependencies. And that's a much better outcome than having, on the face of it, a contract which actually commits you to carrying out whatever these dependencies are. Certainly, it makes the discussion around liability a bit easier for you in the context of being a customer. If your obligation as a customer is only to pay the fees when they're paid, when they fall due for payment, that's quite a different risk profile than having to pay fees, but also to having to satisfy a whole lot of other contractual obligations. Okay, got to move on to my next top tip, which we'll run through just before the end of the session. We're running a bit out of time, but I'm a big fan of plain English. And by plain English, I don't mean dumbing down the language that we use. It doesn't need to be understood necessarily by your grandmother, unless your grandmother is a reasonably educated non-lawyer who's familiar with the subject matter of the contract. The legal concepts that we rely on still need to be accurately stated. So you need to put it in terms that can be read by reasonably advanced people that are familiar with contracts, but who aren't trained in legalese. And plain English also works the other way. So try and avoid industry jargon where it's not clear what the term means, where often people don't actually, the term that is used doesn't mean what people think it means. There's a lot of misunderstanding in certain contexts, in certain industries, especially the IT industry, as to what a lot of this jargon means. So the contract needs to be understandable by you as the lawyer drafting it as well. Look, avoid Latin if you can, which you almost certainly can do. The term mutatis mutandis, which some of you might be familiar with, often doesn't quite work the way we think it will. But look, I'm really happy to embrace the use of te reo in the right context. And I've seen a great example of that in a dispute resolution clause, which contemplated that the disputes would be resolved kanuhi ki te kanuhi, which means face to face. Look, it made a lot of sense in the context of the contract. We knew what it meant, the parties knew what it meant. So I was really pleased to see that use there. And also avoid those archaic terms that, to be honest, makes everyone despise us lawyers. So the herein's, the hereofs, the hereinbefores. No one else seems to write like this, and for good reason. It can actually be quite difficult to understand what's meant by these terms when you're not used to seeing them. So it takes longer to figure out what was meant by the term than maybe writing out in full. Herein could be replaced by in this agreement. I've got a soft spot for the term hereby, which is quite useful for acting as confirmation that the document is actually the one that gives effect to, say, an assignment, for example. Like, final top tip, obviously markups are a really useful way of tracking the progression of a draft, but negotiations are pretty fluid, so drafting should be fluid as well, in my view. So don't be afraid to redraft a clause from scratch based on where you've ultimately got to in a negotiation. You're working through a clause, you've figured out what the parties actually agree in terms of the commercial and legal position. So draft the clause as if that's how you drafted it, if that's how you'd known the clause would end up that way. It's going to end up with a much clearer result, and you're not going to feel beholden to the original text. You probably want to get a bit of buy-in from the counterparty in that case. You'll say, like, this is why I'm doing this. I know we've worked through this negotiation, but ultimately, let's be clear, this is what we've agreed. So this is what the drafting should look like. And if it helps, turn off the markup view or learn how to use a good comparison tool. Don't be scared of the red text, because ultimately, if it gets you a better final product, it's kind of irrelevant. Okay, hope you've all enjoyed my session today. There's obviously a lot to cover, and there's a lot more that we could cover. If you're interested on reading a bit more, these are some of the resources that I follow. So blogs about contract drafting, when I'm feeling particularly, when I need some Saturday morning reading. Ken Adams is the author of a manual of contract drafting style. He's an American author, so he has a particular style, but he has some very good points. Mark Anderson, who I've been lucky enough to be taught by a couple of times. He's got an interesting view mostly from the perspective of an IP practitioner, but some really useful tips and things to think about in the context of drafting. Wright, which is a New Zealand blog, which has a local flavour to it, of course. Contract Nerds, which as the name suggests, is for people who are really interested in contracts, but not just the contract drafting techniques, but also the process of pulling together contracts and negotiating contracts as well. So that's run by a woman, Nadia Al-Najafi, who's an American. So obviously take that with in its context, but a really useful resource. And then for some light relief, if you want to share the pain, especially of being an in-house lawyer, I recommend you follow Alex Sue on LinkedIn. He's in-house counsel, and he likes to share some quite funny TikToks and short videos through his LinkedIn as well, which set up and parody the sort of drafting process or the interactions between in-house counsel who are drafting contracts and the business that they're working with. Look, I've had some good questions come through, and as I said, there'll be a follow-up to today's session where we'll provide these links and also summarise our top tips. So I hope you really enjoyed it all. If you really did enjoy it, you can, and you're not sick of my voice, you can join Hayley Miller and myself in a few weeks' time where we talk to you about the Privacy Act 2020, 6 months on, or 6-ish months on, since it came into effect. So really hope to see some or all of you there at that session. Thanks very much for today. Hope you've enjoyed it. Here are my contact details. Happy to take any direct questions, or if you dispute anything that I've said today, I'd really love to hear about it. Because, as I said, there's not too much literature or resource around the skill and the techniques of contract drafting. It's still very much, I think, developing, certainly as technology helps us do this job. So any feedback would be greatly appreciated. All right, thanks everyone. I'll leave you to enjoy the rest of your days.